just before I begin, can everybody see my screen? Good, perfect. As Carrie was saying, my name is Matt Suchin. I am a 1L student at the Borlaskin Faculty of Law at Lakehead University. Today, I'm going to be discussing the relationship between forest management planning and public participation. But before I begin, I'd like to extend a big thank you to the Canadian Environmental Law Association and Environment North for all their support and guidance throughout this process with my research. Specifically with a big thank you to Carrie and Bruce Heyer. The guidance that they offered me throughout this research has been very much appreciated. And yeah, without further ado, I'll begin. So the focus of my presentation today is I'm going to be discussing the 2023-2033 Wabedaugang Newtming Forest Management Plan, in which there's a proposed road extension that allows private companies to access various areas of the management unit to complete various foresting harvesting activities. The area in question is prescribed through land use designations for alternative purposes, mainly remote commercial tourism, and it's also an acknowledged area for capable caribou habitat. For some time, scientific studies have found that increases in anthropogenic disturbances in the area have led to declining caribou populations in both short-term and long-term trends. So today, this webinar will review the various obligations of the provincial government to promote conservation and within the forest management planning processes. And I'm hoping to highlight the tools, techniques, and strategies that the public can use to participate and engage with the forest management planning process by using the case study of the Wabedaugang Newtming Forest Management Unit as an example to illustrate how to get involved. So the agenda for today, I'm going to present a brief overview of the case study, being the Wabedaugang Newtming Forest, discuss the issue, why the issue is important, and discuss who's involved in the issue. And then I'm going to relate that to how the public can participate in Ontario government forest management planning decisions and discuss the administrative applications for relief parties unsatisfied with the proposal can undertake. So the main questions for today is on a more broad level, how can the public participate in forest management planning? And on a more localized level for the case study, what limitations should be placed on the proposed road extension scheduled to be constructed in the upcoming Wabedaugang Newtming Forest Management Plan in order to ensure that future forest sustainability is being protected. So with the case study, if you look to the map on the right-hand side there, that is the Wabedaugang Newtming Forest Management Unit. It was formerly the Armstrong Forest and recently became the Wabedaugang Newtming Forest Management Unit. And within the forest management unit, the planning committee has divided up the whole management unit into specific sections called Dynamic Caribou Habitat Schedule blocks, or DCHS blocks. And as you can see, they're all different color coded on that map there. So the main purpose of these DCHS blocks is to ensure that the forest management, the harvesting activities are being conducted in a way that still reserves key suitable habitat for caribou in the area to promote their conservation. And if you look to the map on the right there as well, the red lines indicate the primary roads that are currently in place in the management unit. And the yellow lines, they're a little bit harder to see, but those indicate operational or branch roads. All right, so the case study is mainly going to be, if you look to the map on the left-hand side there, the map of Ontario, the red circle indicates the broad area where the discussion is taking place today. The Wabedaugang Newtming Forest Management Unit is on the northern shore of Lake Nipigon. And if you look to the map on the right, you will see a more detailed map illustrating the DCHS blocks within the management unit. And interestingly enough, they are color-coded to show when they are going to be scheduled for harvest. So the schedule for harvest, as I mentioned before, is it varies to ensure that there's always going to be some sort of suitable caribou habitat. The main DCHS blocks that I'm going to be discussing today are in the northern central portion there. So if you can see blocks AB3, D4, B2, C4, and AB4 right in the middle at the top, those are the ones that are mainly going to be in this discussion. So it's important to preface this conversation by talking about caribou sustainability in the area. The integrated range assessment for woodland caribou and their habitat, which was a scientific study conducted by the Ontario government and the Nipigon Range in 2010 and then reviewed in 2014, held that currently within the management unit itself, 66.4% of the territory is online. So what does online mean? Online habitat means essentially habitat that is currently and presently able and suitable to support caribou self-sufficiency and act as a habitat. It's also important to note that the threshold level, as indicated by the federal government for undisturbed percentage of land, should be around 65%. Again, this is more of a, this is related to the provincial government. So the management threshold is more so just more of a standard. In 2014, it was assumed that the area disturbance could be as high as 48%. But the main thing is the management unit held that, or sorry, the integrated range assessment held that in 2014, the range was unlikely to sustain caribou. And there was a suggested decline in the trend over the short term, and long-term population indicators also suggested a trend. Now, if you look to the map on the left there, that is what the current online percent of caribou habitat is in the management unit to date, 66.4%. And if you look in the top center area where AB4, D4, B2, C4, and AB4 are, that is currently online. So it's a question of whether or not further forest management practices, if in recent times there's been a declining trend in population, can still support it in the long term. If you look to the map on the right-hand side there, the winter sustain, that's a map that shows the density of preferred caribou winter habitat, and the refuge habitat also coincides with that map as well. So that's important to promote caribou self-sufficiency, as winter and refuge habitat is important for calving. And the areas in question we're discussing today are noted for their calving. The map on the left shows after the first harvesting schedule in 2031, the number of online percentage of the management unit is dropping by 11%. And if you look and compare the maps together, AB3, B2, and AB4, which are key centers for winter suitability, are going to be depleted. So as I mentioned before, if it's at 66.4% and that diminishes 11% over a 10-year term, how is that going to impact local conservation initiatives? Over the long term, as I mentioned prior, the management threshold for the federal government is recommended at 65%. Although the Nipigon range isn't just exclusively this management unit, the 65% is a good kind of standard to be applied. The map on the left indicates how much of the management unit is going to be online during 2061 to 2081, so merely 40 years from now. And it's dropping to, as you can see, 38.9%. So the total online habitat is currently approximately 400,000 hectares, and that's going to drop to 232,000 hectares in a mere 40 years time. So it's a question of, like I said before, whether the short-term sustainability can suffice and along with the long-term sustainability. And if you coincide the two maps again, the current essential habitat for winter habitat for caribou is almost all going to be depleted by 2061 to 2081 harvest schedule. So the Crown Land Use Policy Atlas designation for the area, being the Caribou Lake and Wabakimi designation, is jurisdiction CLUPA G2616. And what this states is that the primary use for this area will be commercial tourism, and extractive activities such as timber harvesting, while also growing in importance, must remain secondary. Road access will be managed to maintain commercial tourism and fish and wildlife habitat. Land use conflicts will be resolved, recognizing the importance of commercial recreation in the area. So what this is saying is essentially that commercial tourism is the primary focus, and until that primary focus is sufficiently fulfilled, then harvesting activities can take place. It's also important to note in 2014, there was an amendment to the designation that says it has to acknowledge the range management policy in support for woodland caribou conservation and recovery, promoting the long-term self-sufficiency of caribou in the area, and the designation has to reflect that. So because remote commercial tourism is a primary focus, I thought it'd be beneficial to highlight what that actually entails. So remote commercial tourism focuses on resource-based tourism values, such as the habitat, ecosystems dynamics, and resource sustainability. What's interesting enough is that the forest management plan itself acknowledges the need to conduct the forestry harvesting operations in a timely and efficient manner to minimize the impact of tourism in these values. So harvesting, it's acknowledged in the forest management plan, directly goes against these commercial tourism values. Additionally, the forest management plan also states that at the end of the operations, the management unit must have the same level of remoteness as at the beginning. This suggests that prescriptions should be placed on operational roads, such as them being decommissioned and regenerated after the operations, and leans away from more primary access roads. And this is also highlighted by the local citizens committee, who states that they essentially want the area to remain virtually roadless and the roads should have the least possible impact as possible. All right, so this map here, the map on the left, in October or early November of 2021, the planning committee actually decided to go ahead with the McKinley Road extension. This was a positive win because in relation to the proposed alternative being the Dalton Road, that was going to go directly into the path of more well-recognized Caribou sustainability areas. So the McKinley Road that was accepted is highlighted in the green there. And the main issue of this discussion today is going to be, if you look on the right-hand side, that little extension piece, that's about 25 kilometers of roadway. And it's going to be connecting the B2 DCHS block all the way through AB3. How they're going to do that is they're bisecting the D4 DCHS block, and I'm going to be discussing that later. The issue with roads bisecting blocks and caribou habitat is scientific studies have found that caribou with anthropogenic influences are more likely to survive in less suitable habitat. They avoid roadways, they avoid contact, they avoid predation that comes from the roadways. So because of that, they might be condensed into a specific area. So although the areas in question are deemed online, it's a question of what the quality of that is. There's also discrepancies currently happening within the management planning phases regarding silviculture and regeneration issues. So there's many debates about the application of herbicides and the negative potential impacts on human health and environmental health. However, the forest management plan actually states itself that without the use of herbicides and application of herbicides, the long-term management directions of regeneration may not be met. So there's some inconsistencies in regards to that. As I mentioned prior, roads tend to allow for increased predation and access for wolves into these winter habitats that I mentioned are important for self-sufficiency. There are differing opinions, many different groups involved. The local White Sand First Nation believe that the DCHS process focuses too heavily on caribou conservation and not enough on other forestry values. And the White Sand First Nation has also stated that once established, they would like the roads to remain permanent. The local citizens community actually wants further emphasis on caribou conservation initiatives and the promotion of primary land use intentions of these remote commercial tourism values. There are many other discussions happening within the planning committee. However, my presentation today is focusing on the McKinley Road extension. So if you look to the map on the left there, in the top section, D4 at the end of the 2031 harvesting schedule is going to be an anchoring plot in what I've described as a very important area for winter suitability of caribou habitat. And if you look to the right now, the road extension is going to be bisecting directly through it. So even though the block is deemed online, as I alluded to before, it's a question of whether it's going to be of good quality to caribou in that specific area that is so important for their long-term sustainability. So the Crown Forest Sustainability Act is a provincial piece of legislation enacted in 1994, and it essentially gives the forest management plans its legal powers in Ontario. And for the sake of time, I'm not going to go into it in too much in depth, but I just want to highlight that Section 9 states that the minister shall not approve a forest management plan, essentially unless it promotes all forestry values. Section 2 states that sustainability is defined by the long-term health and vigor of Crown forests. And Section 68 states that forest management plans must include and rationalize a description of the forest structure, the composition, and the condition of the Crown Forest. So what all this means is that the enacting minister must not approve any forest management plan unless they are able to rationalize the long-term health and sustainability decisions. So if there's inconsistencies regarding the long-term management direction and the long-term conservation of caribou in the area regarding the road strategy, the forest management plan must adequately address that. So now it's a question of what can be done. There's legislation dealing directly with threatened species in Ontario and Canada, which caribou are, have very little punitive functions for the destruction of caribou habitat. And in fact, various pieces of legislation directly and explicitly state or specifically state that the destruction of caribou habitat is allowed if it's within the forest management plans and the forestry operations. So in regards to legislation, as I said, there's very little that can be done in regards to punitive actions. However, I'm going to highlight some different administrative appeals and things of that nature that parties unsatisfied, not only with the 2023-2033 proposed Watabougang-Newtming Forest Management Plan can undertake, but just in forest management plans in general. First is the Impact Assessment Act, which is a federal piece of legislation enacted in 2019. And it's important to preface this conversation by acknowledging the division of powers between the federal government and the provincial government. So environmental concerns mostly go underneath the provincial government's designation. However, the Impact Assessment Act allows for projects that fall within listed projects that fall within the scope of the federal government to undergo various impact assessments based on their environmental impact. So the application is relatively straightforward. Any member of the community can apply for an impact assessment. But what is interesting about a federal impact assessment act is that the application has to appeal to various federal values, such as human health and rights of Indigenous communities. Those automatically fall within the scope of the federal government. So for an example, in this case study, a potential application could be based on the negative impact of the proposed herbicide application on human health. So if there's an issue with the proposed herbicide application on human health, there might be a recession of the amount of herbicide use. And if that occurs, then the long-term management directions would be skewed to promote caribou conservation, for example. Because the forest management plan is a provincial instrument, it doesn't automatically fall within the scope of the Impact Assessment Act. However, an application can be made. If you look to the graphic on the right-hand side there, it illustrates kind of the processes on how to go about it. First, there has to be a planned project, then an impact statement request is filed. The actual impact assessment is done by a review panel who then make a decision regarding different prescriptions and limitations that should be placed on the projects or amendments of the blueprints and guides of the project itself. And in the post-decision phase, those have to be implemented into the project. So moving on, the Forest Management Planning Manual itself actually has a formalized issue resolution process. So that is very helpful for this discussion. It was first enacted under the Environmental Assessment Act in 1990. However, that was repealed and the issue resolution process was then filed within the Forest Management Planning Manual. For this discussion, an issue that does not fall within the scope of formalized issue resolution processes, according to the Management Planning Manual, is Crown land use planning. So there can't be an amendment made within this process regarding the primary designation of remote commercial tourism and extractive activities being secondary. This application essentially seeks, it's a direct application to the district manager or the regional director, depending on where you are in the process, and it essentially seeks a review of the plans to date and allows parties unsatisfied with the current plans to rationalize their issues as well. Moving on here, this is just a rough kind of map showing how the 10-year plan of a forest management plan works, how like the step-by-step basis of it. Currently, the Watabougang-Newtming Forest Management Unit completed stage 3, I believe, on March 13th of this month. So we will be moving into stage 4 in the upcoming months. And stage 3 was a review of the proposed operations to date. And on FMP Online, the government actually posted the reviewed the review drafts to date and allowed for public consultation to submit their opinions. But this will be more important in my conclusion section. So just keep this in mind as I move forward. So underneath the Environmental Bill of Rights, which was a provincial piece of legislation enacted in 1993, there's an option for an application for review. The legislation itself was enacted to help promote greater communication between the government and potentially aggrieved parties regarding environmental issues. And underneath the Environmental Bill of Rights, it's required that there be an environmental registry to allow for a public forum to discuss these different environmental issues. So an application for review essentially requests the enacting minister to enact a piece of legislation or instrument to examine the need for new policy, an act or regulation in order to protect the environment, or to enact changes, or to revoke an existing policy, act, regulation, or instrument. So it's interesting, the Environmental Bill of Rights inside the legislation states other pieces of law that are applicable for an application for review. And underneath that is the Crown's Forest Sustainability Act. So because the Crown Forest Sustainability Act gives the legal powers to the Forest Management Plan, it is therefore a legal instrument that is applicable for an application for review underneath the Environmental Bill of Rights. What is also interesting is it states that an application for review is not available for any decision made by the government within the last 5 years, unless there is new information that wasn't adequately considered during the original decision-making phase. So if issues regarding the long-term management direction regarding caribou conservation initiatives was not deemed to be adequately and sufficiently considered during the actual planning of the management plan itself, then an application for review could be an option. Finally, the Crown Land Use Planning amendment request is another potential option. This would have more permanent, long-lasting effects unless it was otherwise amended. So the Crown Forest Sustainability Act essentially gives the minister the power to issue a permit to remove forest resources for the purpose of an activity, only if within proceeding with the activity, it abides by different pieces of legislation, such as the Public Lands Act. And if you recall from earlier, the Crown Land Use Designation that states that commercial tourism has to remain a primary focus is given its legal power through the Public Lands Act. So the Crown Forest Sustainability Act gives the power to the Forest Management Plan. And the Crown Forest Sustainability Act has to follow the Public Lands Act, which gives the legal power to the Crown Land Use Designation. So the Crown Land Use Designation still must be abided in the Forest Management Plan. Doing some mental gymnastics here, right? So the minor amendment request might be also a beneficial option, such as saying like any new operational roads have to be decommissioned following their operational use, or winter use only. A major amendment could be an option, but that's way more time consuming as well, such as changing the area to like a conservation reserve, for example. What's interesting is the application process can be triggered by anybody in the community. And the application can be prospective. It can be a preemptive thing. You can look at the potential changes that can occur in the future and base an application on that. And the application itself has to contain various rationales and descriptions and things of that nature. So looking ahead for the future of the case study itself, as I mentioned, we just finished phase 3, we're moving into phase 4. If you look at the second box to the left there, if a request is received during the period of public review of the draft of the FMP in stage 4, the concerned person will make the request for issue a resolution to the MNRF regional director. What this is saying is that essentially it is not too late for the public to still get involved if they have issues in the forest management plan. Broadly, that means that any forest management plan consultation allows for great accessibility for concerned or aggrieved people as well. Similarly, the box beside that, box 3, essentially states that if the outcome of the issue resolution process itself influences the location of a road or road use management strategy for a road, that these findings and the results of this must be necessarily implemented within future FMPs in the area, and also be considered in any drafts that are made up to that date. Something else to keep an eye on underneath the environmental registry, the provincial government is actually currently considering a new public consultation regarding the conservation agreement for boreal caribou. So essentially, the Ontario government wants to redevelop its relationship with the federal government regarding its stance on promoting caribou conservation initiatives. So the findings in that process will necessarily affect the FMPs in the future in Northern Ontario. So with that, again, I just would like to thank the Canadian Environmental Law Association and Environment North for all their help. I've included links should you want to access their website. Similarly, on the far right-hand side, and the last link included, is a link to the Natural Resources Information Portal, where you can access different public consultation initiatives that are ongoing right now regarding the management unit discussion. And again, big thank you to Bruce Heyer and Carrie for all your help. So at this time, I'm happy to answer any questions, should there be any.
Wow.
Thank you so much, Matt. We have Bruce Heyer of Environment North joining us. And so before we go into any questions, Bruce, do you have any remarks or?
I do have a couple of very brief ones. The first is that Matt's analysis is not only interesting legally and bureaucratically, it's also interesting biologically, and Matt has done a good job of integrating the biology, the forestry, the ecology, and a long-term view with short-term legal prescriptions. I'd just like to add one other thing. The DSHS, I call it the Caribou Mosaic. The Caribou Mosaic is an experiment. I personally believe it's a dubious experiment, but as a wildlife biologist myself, there are two survival strategies for an endangered species. One is a long-term sustainability strategy relating to habitat and road management. But even more important, or at least equally important, is a short-term survival strategy. And the DHS, the Caribou Mosaic is focused on the future and makes optimistic assumptions that we can do what we have not yet done on a single acre, is create future caribou habitat by forestry. So I am quite concerned about that. The last thing I would like to add is Matt painted a fairly dismal picture of future habitat supply. Even that assessment is way high because much of the future caribou habitat mosaic is terrain which will probably never be high-value caribou habitat. So for me, it's urgent that we identify the currently used high-value caribou habitat and protect it. The McKinley Road is one area, and there are two others on the unit. That's probably enough for now, but I'm not terribly optimistic about many aspects of the environment these days, but I must say the kind of work that Matt has done here gives me some hope that our young people may yet save us from ourselves. Thank you very much, Matt and Carrie.
Thank you, Bruce.
Thank you, Bruce. We have time for one or two short questions. And I should also remind, Matt's put our email addresses on the screen. And so you're welcome to follow up with us after as well. Or if a question comes to you, pop it in the chat box and we'll reach out. Before we, oh yes, Wendy, I see your hand up.
I just had a quick question about the ministry's responsibility to reach out to people with information about these projects. I've been involved in something similar with some forestry west of Thunder Bay, and our contention was that they had failed in their duty of outreach to the stakeholders and people and organizations affected by their forestry management plan. Is there any law that applies to that kind of thing, or guidance to people who find that the machines are rolling in and they had no idea?
That's an excellent question, Wendy. The first thought that comes to mind, and then I'll pass it back to Matt for his thoughts, but what also comes into play is the Environmental Bill of Rights. And Matt talked about it briefly, but there is a provision in the Environmental Bill of Rights that says, you know, in order for there to be public participation, you must have notice and adequate information. So if you are corresponding with, you know, your local forestry office or the ministry even, I would flag that provision within the Environmental Bill of Rights, and I'll put that exact language in the chat box next, just so you have that in front of you. Matt, anything to add to that?
Yeah, thanks for the question. That's a really interesting question. Just in regards to my research, on a personal note, when I was trying to find these different issues and all that stuff that's going on, it was pretty inaccessible for me, and I was actively looking for it. So I think that question does address maybe a couple shortcomings within the public consultation of environmental decisions. But I think Carrie summed it up within the Environmental Bill of Rights, to my knowledge. That was the main piece of legislation to promote public consultation. So yeah.
Thank you, guys.
Yeah, no problem. And with that, we will turn it over to Redwan, who we're going to shift focus. We're still in the Northwest, we're still in Northern Ontario, but we are going to shift focus to another issue. And so with that, I will pass it over to Redwan, who is going to share his screen. We'll have same style, presentation, brief Q&A, and you're welcome to follow up with us afterwards, should there be questions. Over to you, Redwan.
Good afternoon, everyone. I'm just wondering if anybody could provide me audible confirmation that you're all able to see my slideshow.
Yes. Yeah.
Perfect. Thank you so much. So good afternoon, everyone. My name is Redwan Majumder. I'm a 1L law student at Lakehead University. Similar to Matt, as part of my placement at Pro Bono Students Canada, I've had the privilege of working with Environment North and CELA. In completing this project, I've had the pleasure to be supervised by Carrie from CELA and Dodie from Environment North, who have provided invaluable support and helped me so much with consultation, advice, and resources. I'd also like to thank Miranda from Pro Bono Student Canada's Lakehead chapter, who helped so much in facilitating this placement for me. So prior to getting started, I'd just like to make a quick note that this presentation was prepared with the assistance of Pro Bono Student Canada Lakehead University law student volunteers. Pro Bono Student Canada volunteers are not lawyers, and they are not authorized to provide legal advice. This presentation contains a discussion of certain legal and related issues only. If you require legal advice, please consult with a lawyer. So getting into my research topic is examining the public interest implications of the Nuclear Waste Management Organization's approach to community consultation. And so to get straight into it with some background on my topic, the Nuclear Waste Management Organization, otherwise known as the NWMO, was created and mandated to develop and implement a plan for managing Canada's nuclear waste. As part of their mandate, the NWMO is tasked with finding a willing host for Canada's radioactive waste. At the moment, 2 host sites in Canada remain as potential hosts, Ignis and South Bruce in Ontario. The NWMO have asserted that they will follow through with choosing their host sites as long as they have an informed and willing community. However, concerns have been raised by civil organizations that the NWMO has scoped its community consultations narrowly, resulting in adjacent and communities downstream of the assessment areas being excluded from the future willingness determinations. So in order to further understand the implications of the NWMO's approach to public consultation and implications for individuals, communities, and First Nations, this presentation specifically addresses the 3 following research questions. First, what are the rights of individuals and communities to express willingness and consent in the context of projects which posed significant and adverse environmental, human health, and intergenerational harms? Second, what procedural, natural justice, or human rights are impacted or violated when there's a lack of notice and participation in decisions which directly affect human rights? And third, as the NWMO derives its powers from the Nuclear Fuel Waste Act, otherwise known as the NFWA, what does this act say about community consultation in the context of its willingness determination? And this is an outline of the agenda of my presentation. As you can see here, my presentation is divided into 4 main sections, one pertaining to each of the aforementioned research questions, and then there's a final section which looks ahead and examines the future of this topic. So I'll begin with the rights of individuals and communities to express willingness and consent in the context of harmful projects. One source of rights relevant in this context is the United Nations Declaration on the Rights of Indigenous Peoples, otherwise referred to as UNDRIP. This document sets out the fundamental human, individual, and collective rights of Indigenous peoples. Articles 32.2, 11.2, 19, 28.1, and 29.2 from this declaration are most relevant. So just to go into depth, a little more into depth about each of these articles, as they're not written out in detail on the slide, is that starting with Article 32.2, this article explains that states shall consult Indigenous peoples in order to obtain their free and informed consent prior to the approval of projects affecting their land. This means that once a project affects a community's lands and resources, states, such as Canada as a signatory to UNDRIP, must provide the opportunity for said community to express willingness and consent. Article 11.2 explains that states shall provide redress through effective mechanisms with respect to their cultural and spiritual property taken without free, prior, and informed consent. In the context of this research, this would include Indigenous territories affected by the transmission of nuclear waste. Article 19 then explains that states shall obtain free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. As the NWMO derives its powers from the NFWA, the Nuclear Fuel Waste Act, the procedures adopted under the statute are subject to the principles of UNDRIP, including Article 19. Then Article 28.1 explains that Indigenous people have the right to redress and restitution of their lands, territories, and resources they traditionally owned and have been used or damaged without their free, prior, and informed consent. This right ensures that communities that have already been affected by such projects have a means to seek remedies. And then Article 29.2 explains that states shall take effective measures to ensure that no storage or disposal of hazardous materials shall take place in the lands or territories of Indigenous peoples without their consent. As the NWMO's willingness determination is specific to the storage and disposal of nuclear waste, this article is directly applicable to the issue at hand. The next document to be considered in addressing the rights of communities to express consent is the International Covenant on Economic, Social, and Cultural Rights. So essentially, this is a multilateral treaty which was adopted by the UN General Assembly in December 1966, made effective in January 1976, and ratified by Canada in May 1976. It seeks to protect physical and mental well-being through ensuring an adequate standard of living. The most significant provision within this treaty is Article 11.1. This provision highlights that anything interfering with an adequate standard of living cannot occur without consent. In this context, Article 11.1 can be relied upon by communities outside of the NWMO's designated consultation area to argue that they must be consulted and their consent sought due to potential impacts to their standard of living in the event of radiological exposure. It is important, however, to note that this is a novel application of this article, but regardless, it's helpful for individuals to understand and be aware of their human rights framework which exists. Now I'll spend a little time talking about recommendations for future rights of individuals and communities to express willingness and consent. So Environment North remains concerned about nuclear waste disposal and works with a coalition of other groups in the region, including Nuclear Waste Watch, Northwatch, and We the Nuclear Free North. In response to the November 2020 Natural Resources Canada review of Canada's radioactive waste policy, their waste policy framework, Northwatch, which is a nonprofit based in Northeastern Ontario, recommended to Natural Resources Canada subject shipments of radioactive waste to risk assessments. This assessment, Northwatch detailed, should encompass the wide range of risks and hazards associated with said shipments. Northwatch also asserted that it is integral that both the public and Indigenous individuals have sufficient access to said information. I'll now touch on the second scope of my research, procedural, natural justice, and human rights that are impacted or violated when there is a lack of notice and participation in decisions which directly affect human rights. To answer this, I'll first touch on the rights within the Canadian Charter of Rights and Freedoms, which guarantees the fundamental rights and freedoms of Canadians. So Charter Section 15 provides a lens through which we should approach the Nuclear Fuel Waste Act. It states that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. Thus, it purports communities who are also impacted through potential accident and radiological risk ought to receive equal participation under the NFWA. Then Section 25 of the Charter goes on to say that entrenched rights and freedoms shall not be construed to abrogate or derogate from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada. This means that before any decision is reached on willingness, the NWMO must consider impacts to Indigenous and treaty rights and ensure that constitutional obligations are upheld. This is significant because research has also shown that communities affected by nuclear waste, but are not being directly consulted as part of the NWMO's willingness determination, include Indigenous communities. I'll show maps outlining said Indigenous communities in the next slide. So as we can see here on the left, we have a map of all the Indigenous communities in Ontario, and on the right, we have a map of the Anishinaabe Nation of Treaty 3, and my aim here is to just provide a better visualization of what I'm talking about when I mention how these Indigenous communities are affected. The next subsection pertaining to impacted rights, when there is a lack of notice and participation in human rights decisions, will examine the duty to consult. So the duty to consult essentially is a statutory, contractual, and common law obligation that must be fulfilled by the Crown prior to taking actions or making decisions that may have consequences for the rights of Indigenous peoples in Canada. The court held in the Supreme Court of Canada case, Clyde River versus Petroleum Geoservices, that when regulatory agencies act on the Crown's behalf for project decisions, the duty to consult is triggered. So the NWMO is not a federal regulatory agency. However, they are the organization that is tasked with finding a host for Canada's nuclear waste repository. It's critical that the duty to consult be upheld and rights set out in UNDRIP respected. I'd also like to touch a little on natural justice. Natural justice is a common law principle in Canada, which exists to safeguard individuals in their state interactions. It stresses a duty for the state to act in a procedurally fair manner. It has two central elements, which are color-coded on the slide here, and essentially, the principles of natural justice concern the general manner in which a decision is made and help to ensure that decision makers follow proper procedures in making decisions. Therefore, natural justice rights are affected when the NWMO, in having the authority over Canada's nuclear waste repository, does not involve all individuals, communities downstream of the assessment area being the specific individuals not involved, and these individuals not being involved in nuclear waste management decisions. Now I'll turn my presentation to the principles or provisions set out in the Nuclear Fuel Waste Act, the NFWA, which support and argue against the NWMO's narrow interpretation of community. So the two most significant provisions in the NFWA for the purposes of my research are provisions 8 and 12. To summarize provision 8, section 8.1 of the NFWA provides that the Waste Management Organization, in this context, the NWMO, shall create an advisory council. The goal of this council is to propose approaches for nuclear waste management. Section 8.2 of the Act then goes on to specify that the council must include representatives nominated by local and regional governments and Aboriginal organizations that are affected. The phrasing of this provision, noting both local and regional governments, indicates a broad approach to consultation. It indicates that a broad approach to consultation is envisioned and supported within this Act. To summarize section 12, section 12.1a further signifies the importance of the aforementioned advisory council by noting that they must comment on the NWMO's proposed approaches for the management of nuclear waste. Section 12.4 then specifies that each of the proposed approaches must include some sort of comparison of the benefits, risks, and costs. Within this comparison, there must be consideration of the economic region in which said approach will be implemented. Additionally, Section 12.7 states that the NWMO must simultaneously consult the general public on each of their proposed approaches. And I've also included a URL on the slide about the advisory councils that I'm talking about, because I feel like there's so much information to be learned about these councils that the URL in detail explains the purpose of the council and what they can accomplish. Now, moving into the analysis of these sections within the Act, the pertinence of Section 8 specifically is that it opens the possibility for local and regional governments and Aboriginal representatives to have some degree of input in the determination of community willingness and consent. This is because it mandates that the Advisory Council proposing approaches for the waste management must include various representatives from affected communities. And then Section 12 of the Act is applicable, but it is less clear on its face. It stresses the consideration of individuals within affected economic regions. An economic region is specifically a geographical unit generally composed of several census divisions within a province. The distinction of economic regions may support the NWMO's narrow interpretation of community and the reason the NWMO has thus far sought to exclude communities along their transport corridors. For instance, within its willingness determination. This is because Ontario's total transportation routes spun across the province and accordingly do not align with the boundaries of economic regions. However, Section 12 of the Act also goes on to declare that the economic region and the general public must be considered and consulted. This, in turn, creates an argument against the NWMO's narrow interpretation of community because having an impetus to consult the general public allows for more input from various actors affected by the presence and transportation of nuclear waste. I know there's a lot of text on the slide, but I really want to hash out what was said here because the section is so nuanced. Essentially, I color-coded the red text to represent what supports the NWMO's narrow interpretation community, and then the green text represents what argues against the NWMO's narrow interpretation of community. To sum up the results of my research, I have three main final points. So one, the rights of individuals and communities to express willingness and consent in the context of harmful projects are entrenched within UNDRIP and the ICE-SCR. Furthermore, Northwatch's November 2022 policy submission to Natural Resources Canada explains what rights should be ultimately entrenched to protect communities from future harms. Two, the rights entrenched in Charter Sections 15 and 25 are impacted when there is a lack of notice and participation in decisions which affect human rights. Furthermore, it's critical that the duty to consult be upheld and rights set out in UNDRIP respected. Then, point 3, Section 8 of the NWFA argues against the NWMO's narrow interpretation of community, while Section 12 argues both for and against the NWMO's narrow interpretation of community. While this presentation highlighted key points for each of the research questions analyzed, there remains points that can be expanded upon for future analysis. Building upon this research, potential future topics to explore include 1, a case-by-case analysis of individual communities that will be affected by nuclear waste radiation, but as of yet have not been consulted by the NWMO. 2, the role of financial incentives as potential forms of coercing consent from communities who are consulted by the NWMO. This now brings me to the end of my presentation. I've attached links to SELA Environment North, similar to Matt, if any of you are interested in learning more about these two great organizations. I've also attached my email along with both of my supervisors' emails if you'd like to contact any of us. Also, at this moment, if any of you have any questions right now, I'd be more than happy to take them. Thank you.
Thank you so much, Redwan. That was excellent.